Subscribe to our YouTube channel and click the bell icon.
So I'm going to be talking to you about the recent press release by the Ministry of Information Technology and Electronics banning 59 apps of Chinese origin. This happened Monday. Now the MAKI derives its powers under Section 69A of the IT Act, read with what we call as the blocking rules, which allow you to block a certain website or a mobile app. Now the grounds envisaged for such blocking are, and as is evident from the press release as well, are the sovereignty and security of India. Clearly, this has to be seen in the context of the larger geopolitical situation that we are in right now. Now, the government has apparently relied on its emergency powers under the blocking rules, which permit it to do away with any kind of notice or hearing requirements in passing such an order for a period of 48 hours. What happens within these 48 hours? So during this time, the order has to be placed before a committee, which comprises of officials of the Ministry of Home Affairs, the Ministry of Law and Justice, and the Computer Emergency Response Team, amongst others. After this 48-hour period is over, basis the recommendations of this committee, either this order will be sustained or revoked. Now, to our understanding, most of the companies that are impacted have not received any orders from the government so far. So we are waiting for that 48-hour time period to be over, after which these companies might receive a formal order. Right? Now, what is next? One is that after there is clarity, after this 48-hour period, obviously companies are either going to receive a formal notice, basis which they will try and seek an opportunity of being heard before the government, or it is also likely that this orders may be challenged in the court. Now, there are certain grounds available for a challenge. One being that the order itself will have to be very specific with respect to each of these companies as to how they're operating their respective apps has an impact on the sovereignty of the country or the security of the country. If the order fails to be that specific, then that's one ground for challenge. The other issue is that whether a blanket ban is the least intrusive way in which the concerns of the government could have been addressed. For example, if the issue is that there are also officials of the government or of the armed forces who use these apps and their private information is then susceptible, then maybe a less intrusive way would have been to direct government officials and officials of the armed forces to uninstall these apps. So the proportionality of the order which has been of the action taken by the government could be another ground for challenge. The third issue that I want to mention is that these apps are used by millions of people in India. There are means of expression for them and even livelihood in many cases. That being the case, it is possible that not only the companies but the users of these apps could possibly challenge these orders. Now, the orders have not been made public, which make it difficult for somebody from the public to challenge the order. But the Supreme Court, in the judgment of Anirudh Rastogi, ordered that any blocking orders which have a wide-ranging implication on the public at large should be made public. So I think in the next couple of days, and especially after the 48-hour time frame is over, we will have a lot more clarity on how things are going to play out, and with these orders, either being made public by the government or at least being issued to the companies that are going to bear the brunt of this directly. Thank you.
Subscribe to our YouTube channel and click the bell icon.